Access to essential medicines can be substantially impacted by intellectual property rights, particularly in developing nations. There's a conflict between protecting pharmaceutical innovations through patents and ensuring that populations in need have affordable access to life saving medications. Patents are legal exclusive rights for inventing new products, processes, organisms, designs, and plants. For 20 years, the right holder can prevent anyone from creating, using, or selling the protected invention. Governments must often encourage research and development to find pharmaceutical treatments and cures for diseases and other conditions through patents. This issue has real world implications as it impacts the global availability, affordability, and accessibility of medicines. IPR restricts access to vital medications. Access to antiretroviral drugs for the treatment of HIV or AIDS, for instance, was restricted in many developing countries in the early 2000s due to high drug prices driven by patent protection. India played a crucial role in enhancing access by manufacturing generic versions of these medications, thereby substantially reducing costs and enabling more individuals to receive treatment. Another example is the treatment of hepatitis C, which is a global health concern but inaccessible to many patients due to the high cost of patented medications. As a result, a number of nations, including Egypt, employed measures to enable the production of affordable generic versions of hepatitis C drugs, resulting in a significant increase in treatment accessibility.
Now, moving on to the legal challenges. Intellectual property rights, such as patents, are intended to protect the innovations and investments made by pharmaceutical companies in developing new drugs. These protections incentivize innovation and research in the pharmaceutical industry, but simultaneously, these patents grant exclusive rights to the patent holders, allowing them to set high prices for their medications, making them unaffordable for many individuals in regions with limited financial resources. Now, the issue of IPRs and access to medicines presents several legal challenges. First is the patent protections and monopolies. Pharmaceutical companies often obtain patents for their innovative drugs, granting them exclusivity to produce and sell the medications at high prices, creating monopolies that hinder generic competition and limit access for vulnerable populations. Second is the TRIPS agreement and flexibilities. The World Trade Organization's agreement on trade related aspects of intellectual property rights sets global standards for IPs, including pharmaceutical patents. However, TRIPS also includes flexibilities that allow countries to take measures to protect public health and promote access to medicines, known as TRIPS flexibility.
The third legal challenge is parallel imports, which is the importation sale of generic pharmaceutical products from one country to another without the consent of the IPR holder. This practice aims to overcome price differences between countries, allowing parallel importers to offer medicines at a more affordable rate in markets with higher prices due to stronger patent protection. While this practice may increase access to medicines, it can lead to disputes with patent holders, impacting pharmaceutical companies' profits and potentially hindering our investment in R&D. The last legal challenge is counterfeiting, which involves the illegal production, distribution of fake medicines. Counterfeiters typically target expensive and hard to obtain branded drugs with strong IPR protection. These fake medicines pose a significant risk to public health as they may lack essential active pharmaceutical ingredients or contain harmful substances. As a result, patients unknowingly using these counterfeit medications are put in danger as the safety and effectiveness of these treatments are compromised. Moreover, the prevalence of counterfeit drugs can erode trust in legitimate pharmaceutical products, leading to reduced confidence in the healthcare system and negative impacts on global health.
Let's explore two key points on addressing intellectual property rights and access to medicines. Firstly, we have trade flexibilities, which have proven instrumental in times of crisis. During the AIDS epidemic, millions in sub-Saharan Africa struggled to afford antiretroviral drugs due to patent barriers. In 2001, Brazil broke through this obstacle by invoking trade flexibilities and producing generic versions of these medications. As a result, treatment costs dramatically reduced, and the country achieved remarkable success in expanding access to life-saving medicines. Secondly, voluntary licensing has made an impact in the fight against hepatitis C. In 2014, Gilead Sciences, a pharmaceutical company, allowed 7 Indian generic manufacturers to produce and distribute their patented hepatitis C drug at lower prices. As a result, countries like Egypt could provide affordable treatment to thousands of patients, significantly improving access and saving countless lives. In this slide, you can see the regions affected by the HIV epidemic, which mainly affected sub-Saharan Africa. In this slide, on the left, you could see the effect of generic competition of the price reduction and number of patients accessing ARVs in Uganda. On the picture on the right, you could see Egyptian workers lining up near a van for an examination checkup for hepatitis C.
Various organizations such as the Medicines Patent Pool and Unitaid are diligently working to improve access through technology transfers, price reduction, and promoting generic competition. In Canadian context, these initiatives have found legal backing in international agreements like the World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights. This agreement allows for compulsory licensing, which permits governments to grant licenses for the production of patented medicines without the patent holder's consent. This facilitates for the availability of affordable generic medications, especially for life-threatening situations. While these efforts are commendable, a delicate legal balancing is necessary. The protection of pharmaceutical research and innovation is supported by international intellectual property agreements, such as patents, which encourage investment in drug development. Striking the right balance between intellectual property protections and ensuring equitable access to medicine remains an ongoing challenge.